Now, who wants faster internet? And who wants better roads? One of the reasons we aren't getting these pretty new things yet is due to the overloading of the court system. This overloading slows the rate at which criminals are trialled and sentenced, and expends resources monitoring them over an extended period of time. Criminal cases will, as a rule, have to be resolved in the court system, so there is little room for manoeuvring here without introducing an entirely new system of dealing with these matters. With tortious cases, however, it is entirely up to the would-be plaintiff and defendant to decide how and where the dispute is to be resolved. There are numerous methods of alternative dispute resolution systems available, which will not only benefit both parties by generally having a far shorter processing time, this will also more likely be a lot cheaper and far less adversarial compared to the courts. The judge's decision may also not be what is wanted by either party. The Administrative Appeals Tribunal is an alternative to a court proceeding. It is given power by Commonwealth administrative law. These tribunals allow a relatively fast review of decisions made by various members of Parliament and other officials, as well as the decisions of other tribunals. This is generally reserved for those who have exhausted other non-court methods. For example, if you complain to your ombudsman about council workers obstructing your driveway under the direction of a member of the local council to no avail, you would take this to the Administrative Appeals Tribunal. The Social Security Appeals Tribunal is also given power by the Commonwealth administrative law. This tribunal deals with complaints in regards to social security, education, training payment, social security, education or child support allowances. There are 3 more tribunals empowered by this system as well, several other state tribunals, which have to do with matters from visas to child custody, all outside the court system, and in a far more cost-effective way, which lessens the strain on our judicial system. The tribunal system is an excellent addition to these alternative dispute resolution systems, but the methods I would urge you to employ are the systems of negotiation, mediation, and arbitration. These methods are about as outside the government-regulated systems as you can be, unless you happen to be Batman. The negotiations involve the 2 parties with the dispute attempting to come to a mutually desirable outcome. Lawyers may or may not be present. This method clearly, with its simplicity, has a propensity to be far cheaper and faster than the court system, provided the parties are cooperative. However, if there is a difficulty with negotiations, the mediation system may be useful. This involves a neutral third party, who is usually a solicitor, facilitating the discussion. They have no power to enforce an outcome, but their knowledge and objective view of the situation generally provides invaluable insight. If the parties are too at odds with each other for even mediation, then the arbitration method may be necessary. This involves a neutral third party, also usually a solicitor or a person with legal training, deciding the dispute after hearing the submissions. This decision is binding, unless there is a fault with the arbitrator. An additional advantage of these methods is that the resolution and proceedings can remain entirely confidential, so the reputation of one or both parties remains untarnished. The benefits of these alternative dispute resolution systems appear to be many when compared to the slower and far more costly court system. So, unless you are some new superhero Disney is about to acquire, I thoroughly recommend taking advantage of these alternative dispute resolution systems. I've stopped.